Today, we're tracking a ghost. We're going to follow the life cycle of a single credit card swipe. Let's just say it's a $5 latte. We're going to follow it from the moment you tap your card at a terminal all the way to a courtroom floor, maybe 5 years later.
We're calling this the 0 to 100 journey.
Exactly, the 0 to 100 journey.
It sounds a bit like a detective story, doesn't it? But it's actually, it's purely mechanical when you get down to it.
Right.
We're really just looking at the invisible sort of industrial machinery that powers the entire global credit system.
Yeah, and what we found digging through the research is that this machine, it's incredibly efficient at one thing, moving money.
Oh, absolutely. Billions of dollars a second.
But it's shockingly bad at keeping track of who actually owns that money.
That's the contradiction at the heart of it all.
And we should be clear, we're not just theorizing here. Based on the stack of documents we've gone through, we're talking legal treatises from the National Consumer Law Center, federal court decisions like the big one, Hinkle v. Midland.
A huge one, yeah.
And even technical manuals on asset securitization. This isn't just about a few accounting errors here and there. It's about a fundamental clash of systems.
That is the core tension we really need to explore today. You've got the financial system on one side, and it's built for speed, for liquidity, for trading.
High velocity.
High velocity, yeah. But then you have the legal system, and it's built for the exact opposite. It's built for evidence, for specificity, and above all, for proof.
And when those two worlds collide, which they do in every single debt collection lawsuit,
the results can be, well, chaotic is a good word for it.
So our mission for this deep dive is to decode that collision. We're going to look at securitization, the true sale doctrine, the specific documents required to prove ownership.
And something the sources call the Trinity of Proof, which is what debt buyers so often fail to produce in court.
And for you listening, the value here isn't just, academic financial theory.
No, not at all.
If you can understand how this chain of ownership breaks, you understand the roadmap for how to challenge a debt collection lawsuit.
It's really about holding these multi-billion-dollar entities to the burden of proof that the law actually requires of them, the same standard anyone else would have to meet.
Okay, so let's start at point 0, the swipe. I'm at the coffee shop. I tap my Visa card. It's issued by, let's call them Big Bank X.
Okay.
In my head, I've just created a very simple contract. It's between me and Big Bank X. I borrowed $5. I owe them $5. Simple.
Right. In your head, yes. And logically, that makes perfect sense. That's how it should work.
But it's not what happens.
But on the back end, inside the financial plumbing, that is almost never what actually happens.
So to understand why, we have to talk about this huge concept, securitization.
Right. This is the engine. It's the engine of modern consumer credit. And it fundamentally changes the nature of what you think of as your debt.
So let's really unpack that. What is the bank actually doing with my $5 debt for that latte?
Okay, so the bank, which in the lingo we'd call the originator, often doesn't want that debt just sitting on its balance sheet.
Why not? They make money on the interest.
They do, but if they hold onto your debt directly, it ties up their capital. They have to keep a certain amount of money in reserves against it because of regulations. They want to lend that money out again to someone else.
So they want it off their books.
As fast as possible. So, to free up that capital, they execute what is legally called a true sale.
A true sale. That's an interesting term. It kind of implies there could be a fake sale.
And in the eyes of the law, there absolutely is. If the bank just pledges your debt as collateral for a loan they take out, that's not a sale. A true sale means the bank actually sells the receivables.
And what are receivables exactly?
It's the legal right to collect your future payments. They sell that right to a completely separate, legally distinct entity.
And this entity is usually a special purpose vehicle, an SPV.
Exactly. An SPV, or more commonly for credit cards, a trust.
And it isn't just, a department down the hall of the bank headquarters.
No, and that's a critical point. It has to be a distinct company. It's usually structured as a trust with an independent trustee. Yeah. And the whole reason they do this is to make the assets bankruptcy remote.
Bankruptcy remote. That sounds like Wall Street jargon.
It is, but it's crucial for the investors. If Big Bank X collapses tomorrow, the investors who bought into that trust, they want to know that the creditors of the bank can't come after their assets.
I see. So the assets are safely locked away in the SPV.
It's like a firewall. They're legally severing the asset from the entity that created it.
And what's the benefit for the bank, besides just getting it off their books?
It dramatically lowers their cost of funding. Because the assets are now seen as super safe, investors will pay more for them, and it frees up that regulatory capital we mentioned. But here is the massive disconnect for you, the consumer.
What's that?
The bank sells the asset, the right to your money to the trust, but the bank almost always keeps the servicing rights.
Ah, okay. So that's why I still get a bill with Big Bank X's logo on it.
That's why.
And I still log into their app to make a payment.
Yeah.
Nothing has changed from my perspective.
From your perspective, nothing. And this is what we call the split personality of the account. The bank manages the relationship. They send the statements. They issue the plastic card. They're the ones you call when you're angry about a fee.
But they don't own the debt.
But the trust owns the actual money flow, the right to be paid.
One of the sources had a great analogy for this. I think it was the car rental one.
Yes, that one clarifies it perfectly. Let's walk through it.
Okay.
Imagine the bank owns a car. They hold the title to the vehicle, they wash it, they change the oil, they're the ones who hand you the keys.
So they're the rental agency.
Exactly. But, and here's a twist, they have sold the right to the rental income from that car to a separate trust.
Okay, so I, the driver, I'm dealing with a rental agency, which is the bank.
Right.
But every dollar I pay in rental fees is legally destined for the trust, not the bank.
Precisely. So legally speaking, the bank is just the property manager.
And the trust is the landlord.
The trust is the landlord. And this trust isn't just holding your $5 latte debt. That would be, incredibly inefficient.
Right.
It's holding millions, sometimes tens of millions of accounts in what's called a master trust.
A giant melting pot of
A
debt.
giant melting pot of receivables, exactly. And this is where the Wall Street alchemy really kicks in. The trust takes that massive pool of debt and then it issues notes to investors.
And this is the tranching concept we always hear about in movies about the financial crisis.
Yes, it's the very same concept. They slice the risk into layers or tranches. You'll have Class A notes. Those are the safest. They get paid first, no matter what. Then you'll have Class B, which is a bit riskier. And then you get all the way down to Class C, or what's called the equity tranche. That's the riskiest piece.
And how does that work in practice?
It works like a waterfall. Money flows in from you and me and millions of other people paying our credit card bills. That money fills the Class A bucket first. Once that's full, it spills over and starts filling the Class B bucket and so on down the line.
So the guys holding the Class C notes only get paid if there's enough money left over after everyone else.
Exactly. They take the first loss, but they also get the highest potential return.
But hang on, credit cards are revolving debt. It's not like a 30-year mortgage that you just pay down slowly. I, hopefully, pay my bill off every month. How does the trust keep this pool of debt full if people are constantly paying it off?
That is the really unique feature of credit card securitization. It's a revolving structure. As principal payments come in from consumers paying down their balances.
My $5 for the latte.
Your $5, yes. The trust doesn't just hold that cash. It uses that money to immediately buy new receivables from the bank.
So it's constantly refreshing itself.
It's a constant churning machine. New debt replaces old debt instantly. It has to keep the principal balance in the trust stable so the investors keep getting their promised payments.
Okay, so we've got a system designed for, incredible speed and turnover. Assets are moving from the bank to the trust, cash is moving from the trust to investors, and then that cash is used to buy new assets to put back in the trust.
It's a perpetual motion machine of debt.
So why does this matter to the listener who just wants to pay their bill? Or, more to the point, is maybe facing a lawsuit?
It matters because of one of the most fundamental concepts in law. Standing.
Standing. Okay, define that for us.
Standing, put simply, just means you have to be the one who is actually injured to be able to sue someone. You must be the real party in interest. You have to own the claim.
So if the bank sues me 5 years later for that latte debt,
but they sold the rights to my payment to the trust in a true sale to get the tax benefits and the regulatory benefits.
and the bank technically doesn't own the debt anymore.
They can't have it both ways. This is the critical point. They cannot tell the regulators and the IRS, hey, we sold this debt to a trust, it's off our books, we don't own it, and then walk into a courtroom and tell a judge, Your Honor, we own this debt, please give us a judgment.
That seems like a massive, almost fraudulent strategic error. Do banks actually make this mistake?
Constantly. All the time. Because the litigation department that files lawsuits is often completely disconnected from the Treasury Department that set up the securitization deal 10 years earlier. The left hand has no idea what the right hand sold.
Wow. And that's just the problem at the 0.0 phase when the account is still performing.
It gets much, much worse when the system breaks. And that brings us to the next part of the journey, the default.
Right. So the machine hits a snag. The 0 to 100 journey takes a very sharp detour. I lose my job. I stop paying for my lattes. I stop paying my credit card bill.
Right. After about 180 days of non-payment, the bank is required by regulations to charge off the account.
What does that mean, charge off?
It's an accounting term. That means they declare it as a loss on their books. At this point, whether it's the trust or the bank holding it, they want this toxic asset gone. It's messing up their yield calculations for investors.
So it gets ejected.
It gets ejected from the securitization pool or sold directly by the bank into the junk debt market.
And this is where the names we see on commercials and court dockets come in. The debt buyers.
Midland Funding, Portfolio Recovery Associates, LVNV Funding, the list goes on.
And they're not buying these accounts one by one, right?
Oh, heavens no. They're buying portfolios. Thousands, sometimes millions of charged off accounts all at once for pennies on the dollar.
What's the going rate?
It varies, but we're talking maybe 3 or 4 cents for every dollar of debt. Sometimes less if the debt is very old.
So my $1,000 delinquent credit card debt is sold for $40.
Maybe, yes. And because the price is so incredibly low, the sale is almost always as is.
Like a used car.
Exactly. And the sources are very clear on this. These sales rarely include the original underlying documents.
So no contract that I saw.
No monthly statements showing the charges, nothing. It's essentially a giant spreadsheet exchange. They are buying data, not a file full of papers.
And it doesn't even stop with one buyer. The sources describe this as a game of hot potato.
This is what's known as the problem of multiple transfers. It's incredibly common. Debt buyer A buys the portfolio from the original bank. They try to collect on it. They get the low-hanging fruit, the people who pay right away.
And the rest?
The rest, the uncollected accounts. They package that remainder up, and they sell it to debt buyer B for even less, maybe a penny on the dollar.
And then B sells to C and C to D.
Sometimes it goes on for years.
I want to look at a specific example that was in the NCLC source material because it sounds completely ridiculous, but it really highlights the chaos. This was the Providian account case.
Oh, the chain of title nightmare. Yes, this is a classic. It's the perfect example of how impossibly messy this gets.
So walk us through it. Where did the debt start?
It started with a consumer who had a credit card from Providian Bank. Pretty standard. Providian charged it off and sold the debt to a company called Vision Management.
Okay, that's link number one.
Link 1. Then Vision sold it to Great Seneca. Link 2. Great Seneca then sold it to Account Management Services.
I'm already losing track. That's 3 different owners after the bank.
We're just getting started. Account Management Services then sold it to Madison Street. Madison Street sold it to Jackson Capital.
So that's 5 transfers.
And then on the very same day, Jackson Capital sold it to Centurion Capital. That's 6 different owners after the original bank.
And Centurion Capital is the one who finally decides to file the lawsuit against the consumer.
Right. Now put yourself in the judge's shoes. Centurion Capital shows up in your courtroom and says, this person owes me money. But the consumer has never even heard of Centurion Capital.
I borrowed money from Providian. Who are you?
Exactly. So Centurion has the legal burden to prove how they acquired the right to collect on that Providian debt.
They have to prove an unbroken chain of title.
Unbroken is the key word. They need a valid, legally enforceable contract of sale for every single link in that chain. Providian to Vision, Vision to Great Seneca to Account Management, all the way down.
And what happens if one link is missing?
If even one link is missing, let's say the paperwork between link 3 and link 4 got lost, or they have a bill of sale but they can't find the data file listing the accounts, the whole chain snaps.
It's like a relay race. If you drop the baton at lap 3, you can't just pick it up at lap 6 and cross the finish line and claim you won the race.
That's a perfect analogy. Centurion has no legal standing without that complete verifiable chain.
And this is just the problem with debt buyers. The banks themselves are changing names and merging, which complicates things even more.
Hugely. This is the bank merger problem. We've seen massive consolidation in the banking industry over the last 20 years.
Right. MBNA merged into Bank of America. Washington Mutual, WAMU, failed, and its assets were sold to Chase by the FDIC.
But here's the trap that so many debt collectors fall into. They think, well, everyone knows Chase bought WAMU. It was on the news for months.
That's public knowledge, right?
Everyone knows is not a standard of evidence in a court of law. That concept is called judicial notice, and judges are incredibly strict about when they can apply it.
So you can't just hand the judge a printout of a Wikipedia article that says Chase bought WAMU and expect them to accept that as legal proof of asset ownership.
Or a New York Times clipping from 2008. No. The plaintiff, the one suing, needs the official certificates of merger filed with the Secretary of State. They need the specific purchase and assumption agreements from the FDIC receiver. The legal standard requires competent, admissible evidence. A Wikipedia page is hearsay.
So if the plaintiff cannot connect the dots from the name on your original credit card statement to the name on the lawsuit with official legally binding documents,
they lose. They haven't proven standing.
So we've established that this debt travels a long, winding, and often very poorly documented road. Now finally we arrive at point 100, the courtroom.
This is it. Segment 3, the courtroom battle. This is where the rubber meets the road.
And this is where listeners really need to pay close attention. The debt buyer has filed the lawsuit. The consumer is standing there, maybe representing themselves. What specific evidence does that debt buyer need to win?
The sources refer to this as the trinity of proof.
The trinity. I like the sound of that. What are the 3 holy documents of debt defense?
Okay, so if a debt buyer is suing you to prove they own your specific account, they need to produce 3 specific things.
Number 1.
Number 1, the forward flow agreement. Number 2, the bill of sale. And number 3, the most important one, the sale data file.
All right, let's break these down one by one. The forward flow agreement, that sounds like the master plan.
It is. It's the big overarching contract between the seller, let's say the original bank, and the buyer. It sets all the ground rules for their relationship.
So it would say something like, we, the bank, agree to sell you accounts that are charged off that meet these criteria for this price.
Exactly, over this period of time. It establishes that a business relationship exists between these 2 companies for the sale of debt.
But, and this feels like a key question, does that document prove they sold my specific account?
No. Absolutely not. It just proves they agreed to sell some accounts that fit a certain description. That's why you need the second document.
The bill of sale.
The bill of sale. This is the receipt for a specific transaction under that master agreement. It's the document that actually executes the transfer. It'll usually say something like, for value received, seller hereby transfers all rights, title, and interest in the accounts listed in Exhibit A to the buyer effective on this date.
Okay, so now we have a master contract and a specific receipt. But the bill of sale usually doesn't list individual names either, does it? It just refers to this Exhibit A.
Correct. And that's by design for confidentiality. That brings us to the third and the most critical document in the Trinity, the sale data file.
This is the spreadsheet.
This is the spreadsheet. It's the electronic file, usually an Excel file or a text file, that lists the specific account numbers, names, addresses, and balances that were included in that specific bill of sale.
So this is the only document that actually links the general contract to me, the specific consumer being sued.
It is the evidentiary linchpin, and this is where debt collectors fail over and over and over again.
The sources listed some of these common evidence failures that are they're mind-blowing. They really show how these companies operate on volume not on legal precision.
Let's talk about one of the most common ones. It's the generic exhibit tactic.
Okay, what does that look like?
The collector's lawyer will produce that bill of sale, and it says, see Exhibit A for the list of accounts. Then they attach a single piece of paper to the back labeled Exhibit A that just has the defendant's name, account number, and balance typed on it.
Wait, so they just type up a new document specifically for the lawsuit and staple it to the old bill of sale from 5 years ago?
Yes. And a sharp defense attorney, or an informed consumer, will immediately ask the witness on the stand, is this the original electronic data file mentioned in the contract?
And the answer has to be no.
Of course not. The original file had maybe thousands or tens of thousands of rows. This document has one. It's a document created for litigation. It is not a business record that was created at or near the time of the sale.
Which, under the rules of evidence, makes it inadmissible hearsay.
Textbook inadmissible hearsay. It's not a record of the event. It's a record of them preparing to sue you. A judge should throw it out.
What's another common failure? The screen capture really stood out to me.
Yes. The classic Hail Mary. The witness for the debt buyer gets on the stand and says, well, Your Honor, I don't have the full original data file, but here is a screenshot of our company's computer system showing Mr. Smith's info and the balance he owes.
And why isn't that good enough? I mean, it's right there on their computer.
Because a screenshot of their system only proves what is in their system today. It doesn't prove where that information came from.
Yeah.
It doesn't prove that the information was reliably derived from the original sale data file referenced in the bill of sale. It's completely circular logic. It's we own it because our computer says we own it.
And our computer says we own it because we're the ones who typed it into our computer.
Precisely. Without the original file from the seller to compare it to, a screenshot is just a picture of a claim. It's not proof of ownership. It also violates what's called the best evidence rule in many cases.
And then you have just the simple, sloppy clerical errors, like inconsistent names.
This is where pure attention to detail can absolutely kill a plaintiff's case. It's amazing. The bill of sale might list the buyer as Sherman Originator III, LLC.
Okay.
But the affidavit filed with the lawsuit says the debt is owned by Sherman Originator, LLC.
So Roman numeral third versus no numeral. It sounds like a typo.
It sounds like a typo, but in corporate law, those are two completely different legal entities. They have different tax ID numbers, different corporate filings.
Yep.
If entity A bought the debt, but entity B is the one suing you, that is a fatal break in the chain of title.
You can't just gloss over that.
You cannot just gloss over the difference between a parent company and a subsidiary or two related LLCs. The plaintiff has to be the correct legal entity.
And what about timing errors? I read about some truly bizarre examples, like assignments dated before the debt even defaulted.
Oh, yes. Or even worse, assignments that are dated after the lawsuit was filed.
How does that even happen?
It's usually a result of sloppy backdating when they realize they're missing a document, but you cannot sue someone for a debt you don't legally own yet and then hope to buy it later to fill in the paperwork. That's a massive violation of legal procedure and can get a case dismissed with prejudice.
So if a listener is in this situation, simply demanding this trinity of proof forces the debt buyer to show their hand.
It does.
And very often, they're holding nothing but a pair of twos.
That is exactly right. The burden of proof is always on the plaintiff. They are the one who has to prove their case by a preponderance of the evidence. If you, the defendant, simply point out these gaps, where is the full data file? Why don't the corporate names on these documents match? Where is the official certificate of merger? The house of cards very often just falls down.
Okay, this has been a fantastic breakdown of the case against debt buyers. But now let's pivot. Let's go to segment 4. What happens when the original bank sues you?
Right.
Let's say Citibank is the plaintiff on the lawsuit. Surely they have standing, right? I mean, they're the ones whose name is on the credit card.
You would think so. But not necessarily. We have to go all the way back to segment 1, back to point 0.
The securitization?
The securitization, exactly. If Citibank securitized that debt, if they sold it to a trust in a true sale, then the trust owns the debt, not Citibank.
So for Citibank to be able to sue me, they would have to prove that the debt was transferred back to them from the trust.
Precisely. This is a retransfer requirement.
And what governs that? How does that work?
It's governed by that massive 1,000-page document called the Pooling and Servicing Agreement, or PSA. The PSA dictates all the rules of the game for that specific trust.
And what does it usually say about defaulted accounts?
Well, it varies. Some PSA say that when an account defaults and is charged off, it is automatically reassigned back to the bank.
Okay, so if it's automatic, then the bank is in the clear.
Maybe. They'd still have to produce the PSA and show the judge that specific language. But other PSAs say something different. They might say the trust has the option to transfer it back, or that it requires a separate written assignment document for each account that's returned.
And if the PSA requires a written assignment?
And the bank can't produce one for your specific account, then they might not actually own the debt. They might just be the servicer suing in their own name, which is improper and a violation of standing rules in many jurisdictions.
It is just amazing. The bank creates this incredibly complex legal structure to hide the asset from its own bankruptcy risk, but then they forget to follow their own rules when they want to get the asset back to collect on it.
It happens all the time. The silos within these massive organizations work against them.
So what's the strategic move here for a consumer being sued by an original creditor?
According to the sources, the key is to use the discovery process. You can send a formal legal document called a request to admit.
And what does that do?
It forces the bank's lawyers to admit or deny specific facts under oath. You draft very specific questions.
Like what?
You ask. Admit that the account number ending in 1234, which is the subject of this lawsuit, was securitized. Or admit that the receivables associated with this account were sold to the Citibank Master Trust Series 2009A.
You're setting a trap.
You're forcing them to go on the record. If they admit it was securitized, their next job is to prove they got it back. If they deny it, but you're able to find the public SEC filings for that trust that show that all accounts from that vintage were securitized, well, now you've caught them in a lie before the court.
It's brilliant. You're leveraging the fact that the bank's litigation department often has no idea what its finance department did 5 or 10 years ago.
The information is buried, and they often won't do the work to dig it up unless they are forced to.
Okay, I love that. Now let's move to our final segment, segment 5. We're going to leave the courtroom defense for a moment and look at another really powerful tool that consumers have.
Right. We're looking at the Fair Credit Reporting Act, the FCRA, and the Fair Debt Collection Practices Act, the FDCPA.
This is what the sources call the Escobar and Hinkle strategy. It focuses on how these debts affect your credit report.
Which is often the main reason people end up paying debts they don't even think they owe. They just want to fix their credit score so they can get a mortgage or a car loan.
So let's talk about that landmark case, Hinkle v. Midland. Why is this specific case so important?
Because the 11th Circuit Court of Appeals made a critical ruling. They ruled that the act of reporting a debt to a credit bureau, to Equifax or Experian or TransUnion is, in itself, a form of debt collection.
That sounds simple, but what's the implication?
It's a huge distinction. It means that if a company reports false or unverified information to your credit report, it's not just a clerical error. It's an illegal collection tactic designed to pressure you to pay.
I see. So Hinkle set a new standard for what happens after you dispute a debt.
A much higher standard. Here's the scenario. You look at your credit report. You see a collection account from a debt buyer like Midland. You send a dispute letter to the credit bureaus. You say, I don't believe I owe this, or this balance is wrong.
Okay, so the credit bureau has to, by law, forward that dispute to Midland and ask them to investigate.
Right, and Midland has to respond. Now, before the Hinkle decision, what do you think they would do?
I'm guessing they'd just look at their own computer screen.
That's it. They'd check their own internal database. Yep, our screen says he owes it, verified. They'd send that back to the credit bureau, and the negative item would stay on your report.
A very low bar.
Incredibly low. Hinkle says that is not enough. The court ruled that if you are a down-the-line buyer of debt, meaning you didn't get it from the original bank, you cannot just rely on the data you were sold. You must conduct a reasonable investigation.
And what does reasonable mean in this context?
It means you have to look for account-level documentation. You have to try to get the original applications, the monthly statements, the promissory notes, the actual evidence of the debt.
The stuff they almost never have.
The stuff they almost never have. And if the debt buyer cannot verify the debt with those kinds of original documents, they cannot legally verify the dispute. And if they can't verify it, they must instruct the credit bureaus to delete it.
That is incredibly powerful. They can't just say, our computer says yes. They have to be able to prove the paper says yes.
Exactly. And this connects to another clever argument, which is the Metro 2 argument.
What is Metro 2?
Metro 2 is the standardized electronic format that all creditors and collectors use to report information to the credit bureaus. It's the industry standard. And that standard requires monthly reporting of an account's payment history.
But debt collectors are notoriously bad at this. The sources mention these things called dispute gaps.
Right. You'll look at your credit report and you'll see a collection account. It might show it reported in January, then in February, and then nothing for March, April, May, and then it suddenly reports again in June. Yeah. There are gaps in the reporting history.
What's the legal problem with that?
This is what's called the Escobar-style argument. It says that if they, the debt collector, agreed to follow the Metro 2 standard, which requires monthly reporting, but then they have all these gaps, they are providing inaccurate and misleading information.
I see.
More importantly, if they are reporting a debt that they can't fully document and using that reporting as leverage to get you to pay, they are using false, deceptive, or misleading means to collect a debt. And that is a direct violation of the FDCPA.
So it's a pincer movement. You use the FCRA to demand an investigation that they probably can't perform.
Right.
And you use the FDCPA to punish them for reporting the unverified debt in the first place, especially if they're doing it inconsistently.
That's the strategy. And the damages under these laws can be significant. The sources make a really important distinction between a negligent violation of the FCRA and a willful violation.
Okay, what's the difference in terms of dollars and cents?
A negligent violation means they were just sloppy, they made a mistake. If you can prove you were harmed, say you were denied a loan because of their error, you can sue for your actual damages.
Okay.
But willful is a different animal. Willful means they acted with reckless disregard for the law. They knew, or should have known, what the rules were, like the standard said in the Hinkle case, and they just ignored them.
And if it's willful?
For willful violations, you can sue for statutory damages, attorney's fees, and most importantly, punitive damages.
Punitive, that means punishment.
Exactly. It's money designed not to compensate you for a loss, but to hurt the company and deter them and others from engaging in the same behavior again. It doesn't even matter if you lost any actual money. If they were reckless with the integrity of your credit report, they pay.
This is just incredible. We've gone from a simple swipe for coffee through the labyrinth of securitization to the junk debt market into a courtroom and now onto a credit report. It's a full ecosystem.
And throughout this entire complicated journey, the one recurring theme is this fundamental disconnect between the speed of finance and the rigor of law.
That's a perfect way to bring us to our outro. Let's synthesize all of this for the listener.
The financial system, at its core, is designed for liquidity and risk dispersion. It wants to turn your personal debt into a tradable asset as quickly and efficiently as possible.
So it groups millions of accounts together, it abstracts them into numbers on a screen, and it sells them off. It's an assembly line.
An incredibly fast and profitable assembly line. But the legal system is the opposite. It's artisanal. It's handcrafted.
I like that.
The legal system demands specific proof for each individual case. It demands the unbroken chain of title for your account, not for the portfolio it came in. It demands the authenticated data file that contains your debt.
So the real aha moment from all this research is that the very mechanism that makes consumer credit so profitable for bank securitization is the same mechanism that strips away the paper trail required to prove ownership in a court of law.
They traded the ability to easily prove ownership for the ability to easily trade the asset. They made a choice. And the law says you can't have it both ways.
That's such a profound realization. This isn't about getting off on a technicality, as some might say.
Not at all.
It's about exposing a systemic flaw that was built into the machine from the very beginning.
It is about holding them to the exact same standard of proof that any plaintiff in any case must meet. If I sued you tomorrow claiming you owed me $5,000, the court would make me prove it. Why on earth should a multi-billion-dollar debt buyer be held to a lower standard?
They absolutely shouldn't.
And that leads us to a final provocative thought to leave with our listeners. The sources we reviewed strongly suggest that in a vast number of these debt collection cases, perhaps the majority, the entities trying to collect the money cannot prove they own the debt with the rigor required by law.
Which really raises the question, if they can't prove they own it, and we pay them anyway out of fear or ignorance, are we just donating to Wall Street?
It forces us all to ask a fundamental question. Is the multi-billion-dollar debt collection industry running on a foundation of legal proof? Or is it running on the consumer's simple and often mistaken assumption that the system works the way it's supposed to?
That is something I'm definitely going to be thinking about for a long, long time. The burden of proof is real, and the burden of proof is on them.
Always.
Thank you for joining us on this deep dive into the mechanics of debt. We'll see you next time.
Stay curious.